For those on the SAST time zone, I'm sure it's 10 o'clock there. And good afternoon to those on the GMT time zone and other time zones that we also didn't reflect. Thank you very much for being here. My name is Dr. Olivia Wabukona, and I'm going to be chairing this particular session. I want to take this opportunity to welcome you officially to the launch of this Journal of African Law special issue on COVID and the law, which was published officially in December, even though we had some online articles that had started coming out a bit earlier from September on. I also want to take this opportunity to welcome our special panelists who happen to have been contributors to the special issue. So they've been with us on this journey for the last almost 2 years, to be specific. It took a while considering the circumstances. And I also specifically want to welcome our special guests, Professor Jaap de Visser, who's going to be welcoming us officially, since officially we are being hosted by the University of Western Cape, the Dalai Institute. And so without wasting time, I'll run us through the program and a few housekeeping issues, and then we will get started. For purposes of today's particular discussion, we are going to go through the opening session, which will take about 15 to 20 minutes. And then after that, we'll get into the panelists' discussion of their particular papers and the context around them. We have 3 panelists today, 3 papers being discussed, but 4 panelists. 1 paper will be discussed by 2 people. And then after that, we'll get into a Q&A session that is going to take us about 30 to 40 minutes, where our participants will come in and play a key role there in getting the discussion going. And then we will eventually close down. We're hoping the session will take an hour, 45 minutes or so. For the opening discussion, I want to introduce our key presenters, the key people who are going to run this particular discussion. We are going to have Professor Jaap de Visser, who is going to welcome us to this particular event, and later on, our JAL editors. Confirmed is Professor Lutz Oyet from the School of Oriental and African Studies, the Faculty of Law, as well as the Center for Human Rights. But we were also hoping and that our other editor, Sope Williams-Elegbe from the Stellenbosch Law Faculty will also join us. And so without wasting much time, I would want to introduce Professor Jaap de Visser, who is the director of the Dalai Institute and has been so since 2013. But he also has been with the Institute since 1998. So most of us have known the Institute as the Community Law Center, but it obviously was important in spearheading it into becoming the Dalai Institute for Constitutional Law, Governance and Human Rights. He also is a professor of law at the University of Western Cape in the Faculty of Law. Professor Lutz Oyet is a professor of international human rights law at SOS, University of London, and the co-director of the Center for Human Rights Law at SOS. He is also the editor of the Journal of African Law. Professor Williams-Elegbe, hoping she can make it and will be here with us, is a professor at the Stellenbosch Law Faculty. She's also the head of the Department of Mercantile Law and the co-director of the Procurement Law Center, also at Stellenbosch University. Without wasting much time, Professor de Visser.
Good afternoon. Thank you very much, Olivia. Thank you so much for that very kind introduction, and a warm welcome to everyone that's joining us this afternoon. It's wonderful to see so many of you gathered here virtually this afternoon. For us, it's afternoon, and for some of you, it may still be morning. Great to see some familiar faces and some new faces, and I really look forward to listening to the deliberations. I'm going to be very brief. I really want to make this quite short and not take away any time from the content of the discussions, but just a brief set of remarks on the Dalai Institute that is sort of officially hosting you here together with our wonderful partners here today. So the Dalai Omar Institute is a unit that resorts under the law faculty of the University of the Western Cape. And as Olivia already introduced, we used to be called the Community Law Center, and we were established as such in 1990 by Advocate Dalai Omar, who was the first Minister of Justice in the cabinet of the late former President Nelson Mandela. And before that, he established the Community Law Center at the University of the Western Cape, essentially as somewhat of a think tank at that point, mainly informing the constitutional negotiations that were taking place in the early 90s, bringing together leading scholars and activists on human rights and constitutional law, including big names such as L.B. Sachs, who became a constitutional court judge after his stint with the Community Law Center, Bulelani Ngcuka, who was our first National Director of Public Prosecutions, Bridget Mabandla, who became a minister as well, Professor Kader Asmal, who was also a minister in the subsequent cabinet. So it was a congregation of very influential legal scholars, constitutional scholars that influenced essentially the content of the Constitution of South Africa as it arose out of those constitutional negotiations. After many of these stalwarts sort of fled the scene, so to speak, and went into government and joined the bench and took up positions in the government, the Community Law Center reinvented itself somewhat and became a non-partisan research and advocacy unit in the Faculty of Law at the University of the Western Cape. We've always focused on various human rights issues, children's rights, socioeconomic rights, criminal justice, women's rights, and also the governance issues related to multi-level government, provincial and local government, federalism, intergovernmental relations, and those issues. So a wide array of topics come together under what was then the Community Law Center, and we focus our work on postgraduate teaching, applied research, and advocacy. Subsequent to those initial years that were very much focused on the South African Constitution and the South African Bill of Rights, the Community Law Center expanded and started focusing also on matters pertaining to the continent and the African context of human rights and constitutional law became a focal area of concern for us. We renamed ourselves in 2015 to become the Dalai Omar Institute to honor our founding director. And since then we are known as the Dalai Omar Institute. So I'm extremely pleased to be able to just say those few words at the beginning of the session to set the scene for this very critical discussion on the impact of COVID-19 on constitutional law and human rights on the continent. The pandemic has thrown so many challenges at us, personal, institutional, legal, many new issues to be dealt with, many new questions that we never had to confront before in the same way. And of course, it has put tremendous, I think, challenge also to legal practitioners, legal scholars, to come up with innovative solutions and to look at legal issues through the prism of what it means to be living under a pandemic with all the ramifications that we've been exposed to. And I think it's wonderful to see legal scholars taking up that challenge and applying their minds collectively in a collaborative, cooperative fashion to many of these very difficult challenges. So with those few words, let me hand back to you, Olivia, and I'm going to stay tuned, and I'm sure I'll be mesmerized by the discussions in this August panel and gathering. So thank you very much, and over to you, Olivia.
All right, thank you very much, Prof. Divisor. And thank you for that amazing context of the Dalai Omar Center. It's been a privilege working with them. I want to take this opportunity to welcome our editors. I'll start with Lutzu, so a few words about JAL And then we'll also have Sope Williams-Elegbe, who is also here with us. Thank you, Lutz.
All right, thank you, Olivia, and a very warm welcome to all of you on behalf of the Journal of African Law to the launch of the special issue on COVID-19 and the law in Africa. The journal is celebrating its 65th birthday this year, but that does not mean that it is close to retirement, far from it. We continue to publish a wide range of articles on all aspects of law in Africa, with a particular preference for articles of a comparative nature or with a regional perspective. To give you an illustration, our most recent articles include a piece on Islamic law of marriage and inheritance in Kenya, on international solidarity and the global compact on refugees from regional perspective, and presidential term limits and the African Union. The Journal of African Law's recent initiative to publish special issues has been a resounding success. We published our first special issue on the African Charter on Democracy, Elections and Governance at 10 in May 2019, and our second one on refugees, returnees and internally displaced persons in May 2021, both of which are available open access. When COVID-19 broke and became a pandemic, we soon agreed that its importance and the legal ramifications for all spheres of life called for another special issue. The journal received a number of really excellent manuscripts in response to our call for papers. Selecting manuscripts for publications and rejecting several publishable papers was probably the most difficult part of that process, which otherwise was thoroughly enjoyable. In selecting articles, we looked for thematic breadth, local and regional focuses, and original perspectives. And the outcome of this endeavor is therefore of you to see and for us to celebrate today. And I'm delighted that we have with us the authors of 3 brilliant papers on electoral governance and human rights, on poverty and inequality in South Africa, and on women's experience in the Democratic Republic of the Congo. And we're all very much looking forward to your presentations later on, which will be, I'm sure, probably introduced by Olivia. So I skip this part and we'll focus on the other excellent and fascinating articles that you can find in the special issue, all of which are available open access. Fakbayibo and Ovie's article, Crisis as Opportunity, explores the African Union's response to COVID-19 and the implications for its aspirational supranational powers. Adequacy turns the spotlight on the important subject of access to pharmaceutical patents in the COVID-19 emergency, with a particular focus on Nigeria. And in an article that has become particularly poignant in light of the recent coup, Babika examines COVID-19 in Sudan, especially the impact on economic and social rights in the context of a fragile democratic transition and suspended constitutionalism. 2 contributions address emerging COVID-19 related jurisprudence in South Africa. Dube and Duplessis examine unlawful occupiers, evictions, and national state of disasters. And Kamga analyzed the violation of the right to basic education of learners with disabilities in South Africa. Gavu and Mensah's paper provides an important critical analysis of recent legislation on contract tracing in Ghana and its compatibility with privacy rights. Last but not least, in our introduction to this special issue, Olivia Dwabukuna contributed sections on legal scholarship on epidemics in Africa, which is an invaluable resource for anyone interested in studying COVID-19 in a broader perspective. So we strongly recommend that you browse these articles online and promise that you will be richly rewarded. Let me conclude by thanking all authors for their contributions, and of course to thank all my co-editors, Professor Shope Williams-Elegbe, Dr. Olivia Wabunkuna, and Professor Ebenezer Duroyaje. The journal is particularly grateful to the Dalai Lama Institute for hosting the launch today. And I would also like to thank all of you for joining us for the occasion. Before I hand back to Olivia, I wish to acknowledge the difficult times we have experienced collectively and individually over the last 2 years, and to remember those who are no longer with us because of COVID-19.
Thank you very much, Lutz. I'll now hand over the floor to Professor Shope Williams-Elegbe.
Good morning, everyone, or good afternoon, depending on where you are. Thank you so much for that, Olivia, and thank you, Lutz, for your excellent introduction to the special issue. I'm not going to say a lot. I'm just going to say that it was really a privilege to be part of the editing process for this, to see the quality of submissions that we had from writers all over the continent. And I think, as Lutz said, it was really difficult, having to reject some really high quality papers in favor of others. I think Lutz has said it all. This has been a difficult time, and the fact that African scholars are still able to push through with all the limitations that we have in terms of obviously research and infrastructure and access to resources is really commendable. So we really thank everyone who contributed or who submitted. And we're just grateful that we were able to steward and midwife this special issue, which, as Lutz has said, will be really enriching for you if you pick it up. So thank you again for your time. Thank you for your scholarship, and thank you for being here. Olivia, back to you.
Thank you very much, Sope. It was an amazing opportunity for me, obviously, and colleagues to have played a part in editing this amazing spatial issue, but also, as all the other co-editors have pointed out, that the quality of the work that was submitted, the breadth of the work that was submitted, the experiences and exposures on the interaction between law and COVID-19 from different parts of Africa. It was interesting and fascinating, and an opportunity to learn as well as we edited this spatial issue. And obviously, editing it reflects the context within which we were editing it, which was difficult both for the authors and the editors. So I want us to move to the next session where we get into the panel discussion. Perhaps a few things before we get into the panel discussion, and I think that has already been put in the chat session. So we would implore everyone to keep their mics off for the time being, and also anybody with questions, questions would arise as you listen to the panel discussions. Please put the questions. I was looking at the section here. I don't see a section with the Q&A. So you can always, if you don't find any section with the Q&A, question and answer option for you within Zoom itself, you can put that in the chat. And we'll try and see the questions as we go along, but do come up with questions and put them in there so that we have enough material to discuss at the end of this particular discussion. So the way we are going to move into the panel discussion, we are going to start with Mansha Mohi. We will have a discussion of 10 minutes. Then we move to Professor John Mubangizi, and then we'll move to Prof. Caroline Jacobs, and eventually the paper from Jacobs will be shared by Patrick Milabio Kiamusungura, who is in the DRC and obviously might be able to make it or not. We are hoping it manages to get the right connection to do so. And then from there, we can move into our Q&A session. In introducing our panelists, I'll start with Mansha Mohi. Miss Mansha Mohi is a research consultant at the governance section of the Office of the Secretary General and General Secretariat of the African Development Bank Group. She has previous research experience at the Pan-African Affairs Division of the European External Action Service and the Human Rights Unit of the Attorney General's Office in Mauritius. Her research interests include public international law, international human rights law, and African regional integration. Professor John C. Mubangizi is the Dean of the Faculty of Law at the University of the Free State, South Africa, a position he has held since February 2018. Professor Mubangizi's main academic disciplines are constitutional law and human rights, and his research areas are socioeconomic rights, rights of vulnerable and marginalized groups, poverty, human rights, education, and human rights institutions. He has also done research on human rights and gender-related cultural practices, corruption, and public interest litigation. Professor Mubangizi is a renowned academic who has worked at UKZN as well in different senior positions, and is on senior positions in African education governance institutions. Caroline Jacobs is an assistant professor at the Van Volleybone Institute for Law, Governance and Society within the Faculty of Law at the University of Leiden. She has a background in international development and in legal anthropology. Patrick Milabyokia-Mshungurwa is a professor at the ISTM, I can't pronounce it, in Bukavu, in the Democratic Republic of the Congo. He works on participatory approaches to health, governance and social accountability, development and reconstruction, and is currently doing research on social accountability, sexual violence, gender, connectivity, and mobility of displaced people, and on COVID-19 in the DRC. So those are our panelists. Without wasting much time, I'd like to welcome Ms. Maisha Mohi to start our discussion.
Good morning, good afternoon, everyone, fellow panelists and all participants. First, let me thank the host for organizing this virtual launch and for the opportunity to participate in this panel discussion. Thank you also, Dr. Babukuna, for the introduction. So my contribution to the special issues entitled Electoral Governance and Human Rights Amid Pandemics in Africa, Lessons from the Early COVID-19 Experience. The purpose of the study was to map out initial state and regional responses in the conduct of elections as the pandemic unraveled across the continent in its first year, in order to identify trends and distill key lessons for preparedness for future health emergencies from a human rights perspective. The paper addresses the following three questions. What were the human rights implications of state responses in the conduct of elections in Africa over the course of the first year of the pandemic? What state duties and human rights standards can be identified in international law for the conduct of elections during crises, especially infectious disease outbreaks? What have been the main challenges and shortcomings in the conduct of legitimate and credible elections? And what are some potential focused areas, both in a national and regional context, for mitigating the impact of the pandemic on political participation? Just as a reminder, national or local elections were planned in more than 25 African countries in 2020. These included notably the first parliamentary elections in Ethiopia after the 2018 democratic transition, a presidential election rerun in Malawi, high-stake elections in Burundi, and elections in Côte d'Ivoire, with the incumbent president running for a third term last minute. Led to the pandemic, roughly 8 countries held elections as initially planned, whereas at least 12 countries postponed their elections. Notably, Ethiopia announced an indefinite adjournment of elections in March and only drew up an electoral timeline much later in December. States were faced with a spate of challenges in the organization of elections at the onset of the pandemic, including disruptions in electoral registration and planning due to lockdowns, disruptions in the procurement of election material, and the suspension of international observer missions due to travel restrictions, as well as constraints in political engagement in light of bans of public gatherings. The human rights implications of decisions to hold or postpone elections and the conduct of elections more generally were very significant. As is commonly the case in the region, elections were the site of violent political contestation and crackdown on civic space. These human rights violations, however, were further conflated in this context. The overall decline in checks and balances afforded by the crisis, as states and the international community are more focused on public health priorities, gave more room for strongholds on power and democratic backsliding. We can note 5 major issues in this respect. First, political actors widely flouted health and sanitary protocols in political campaigning. Even though in many countries regulations were adopted for the conduct of online campaigns only, large public gatherings were still organized in the lead up to elections. In Malawi, for instance, street rallies were held and infections accelerated rapidly during the electoral period, By the swearing in of the president, the number of COVID-19 cases had more than doubled within 2 weeks. Similar spikes were reported in Guinea and Tanzania. Generally, political candidates played down the extent of the spread of the virus, dismissing health experts during political campaigns, while election management bodies issued guidelines to sensitize voters. Barrier and hygiene measures were not systematically applied by authorities in polling stations. Second, tactics of political suppression were rampant. In Benin, opposition parties were barred from competing in elections in March on the basis of criteria set in a new electoral statute for fielding candidates. When this was challenged before the African Court on Human and People's Rights, the government soon after withdrew direct access to the court for individuals and non-governmental organizations and went ahead to hold the elections. Likewise, in Côte d'Ivoire, the government withdrew direct access to the court in April. This followed the court's order for the suspension of an arrest warrant against prominent political rival Guillaume Soro, who had been sentenced to 20 years in prison for corruption. Third, there were many instances of crackdown on civil space and arrests of journalists and civil society actors. In Egypt, for example, more than 16 journalists were arrested after criticizing the government's handling of the pandemic in the lead up to the elections. Governments also introduced regulations or legal amendments stifling free speech, limiting access to news websites and social media, so on, under the pretext of regulating fake news. Internet access were also cut off on polling day or during the electoral period, such as in Burundi, Togo, and Guinea. Fourth, there was a surge in misinformation and disinformation in that period. As political campaigns moved online, fake electoral announcements were particularly prone to mislead populations. This was seen in Niger, for instance, where a fake social media announcement attributed to the Electoral Commission declared the suspension of biometric voter registration. And finally, state responses also led to the aggravation of peace and security challenges and civil unrest. The indefinite postponement of elections in Ethiopia led to a flare-up of ethnic tensions. The political crisis in Tigray resulted in many deaths, the displacement of large numbers of the population, and severe humanitarian concerns. Similarly, in Mali, a legitimacy crisis caused by the Constitutional Court handing around 30 seats to the ruling party sparked violent protests. In Côte d'Ivoire, elections went ahead despite calls by the opposition for their postponement, leading to several days of protests in Abidjan. Having observed the human rights implications of state responses in elections during the onset of the pandemic, we need to further interrogate state duties in the conduct of elections from a human rights perspective. What is the scope of state duties in safeguarding health in the conduct of elections? How can extant international electoral obligations be refined to respond to accessibility concerns of high-risk and vulnerable voters, such that elections are inclusive? What are the legal conditions and limitations regarding the postponement of elections? A review of relevant international and regional standards, such as the African Charter on Democracy, Elections and Governance, and the AU Declaration on the Principles Governing Democratic Elections in Africa, reveals that the need for ensuring access, inclusion, and timeliness of elections is not adequately prescribed nor sufficiently defined in the context of crisis. These gaps in normative frameworks were recognized at the regional level, as we can see from attempts by regional bodies to guide states as to the legal standards in conducting elections during the pandemic. The chairperson of the African Commission on Human and People's Rights issued a statement in June 2020, shedding light on some of these requirements at the different stages of the electoral process. Pertinently, the statement highlighted state duties in the case of postponements, which included notably compliance with judicial review, the definition of timelines on the basis of full consultations with all stakeholders, clear and equitable interim arrangements, and the respect of constitutional term limits. The AU Commission only issued AU guidelines on elections in the context of the pandemic much later in 2021, despite promising to do so as early as May 2020. We can see in contrast, the Organization of American States issued a guide on holding elections amid pandemics in July 2020. The African Court also provided some guidance, but also with significant delay. The Pan-African Lawyers Union filed a request for an advisory opinion in June 2020, seeking the court's guidance on the legal standards for the conduct of elections during the pandemic. The court only issued the advisory opinion in July 2021. Importantly, though, it held that since the African Charter of Human Rights and the African Charter on Democracy, Elections and Governance leave to domestic law the conditions under which elections are held, Therefore, it is also for states to determine whether or not to postpone an election in an emergency situation. The decision requires prior consultation with health authorities, political actors, and civil society. On the question of state duties to ensure the protection of the right to participation during emergencies, the court referred to the guidelines issued by international institutions, notably the WHO and the AU, and emphasized that the restrictions of rights must be set out in law, proportionate and non-discriminatory. Finally, the court also stated that if elections are postponed, the postponement must be set forth in law and must be proportionate. In cases of a vacancy of power, the legal regime to be adopted must be established in domestic law. Despite these developments last year, a number of challenges still remain, and a few focused areas can be drawn from the early experience of African states and regional responses for future preparedness. First, there is need for a more coordinated approach across the AU and regional economic communities on electoral governance in the midst of the pandemic. Whilst RACs also have electoral guidelines, networks of electoral management bodies, and a stronger understanding of national and local context, these have not necessarily been leveraged in electoral governance amid the pandemic. There's also a great need to address in domestic law standards applicable in the conduct of elections in crisis, including the derogation of rights in emergencies, conditions for postponement, and the legal regime in case of a power vacuum for legal certainty. It is also perhaps time, it's also perhaps time for African states to explore and invest in the secure and reliable use of technology in elections, including alternative voting arrangements, remote voting, and electronic voter registration. These also would need to be adequately regulated in statute. In conclusion, it can be said that the onset of the pandemic in 2020 provided a crucial opportunity for relevant regional and national bodies to define standards for the conduct of elections during global health crisis. This was particularly important for the African continent in light of the prevalence of infectious disease outbreaks in the region. Valuable insights were indeed provided, albeit with considerable delay. However, as the advisory opinion for the African Court demonstrates, much about the conduct of elections is still considered to be a matter of state sovereignty. Therefore, it is clear that national legislation needs to be comprehensively consolidated across countries so that the conduct of elections rests on a rules-based system and be less prone to political expediency during public health emergencies. Thank you.
Thank you very much, Ms. Mansha Mohi, for that amazing discussion and setting of context of COVID-19 within the context of elections in Africa. Just to remind colleagues, the title of our paper was Electoral Governance and Human Rights Amid Pandemics in Africa, Key Lessons from the Early COVID-19 Experience. I also find it interesting, and I'm hoping later that you and Lutz can have a detailed interaction, considering that he was actually involved in part of supporting the writing of the advisory opinion on legal standards for conducting elections during a pandemic in Africa. So that should be interesting. I want us to move now to our next panelists, Professor John Mubangizi, who is going to present a paper on Poor Lives Matter, COVID-19 and the plight of vulnerable groups with specific reference to poverty and inequality in South Africa. Professor Mubangizi.
Thank you very much, Dr. Wabukuna, for the earlier introduction. Thank you also for inviting me to participate in this launch of the special issue of the Journal of African Law dedicated to COVID-19 and the law in Africa. Now, there's no denying that the COVID-19 crisis is the biggest global challenge the world has faced in modern times. There is also no denying that COVID-19 has infected and affected millions of people worldwide, many of whom have actually perished. Its devastation on national economies, public health systems, social relationships, human interactions, etc., is still ongoing. In fact, the effects of the pandemic will be with us for a long time to come. Now, over the last 20 years or so, I've done some substantial research and published widely on topical human rights and constitutional issues. So when I saw the call for papers for this particular issue of the journal, I was quite excited because I immediately thought about the impact of the pandemic on the rights of certain groups of people, particularly those that are most vulnerable. Hence the title of my article, Poor Lives Matter, COVID-19 and the Plight of Vulnerable Groups, with specific reference to poverty and inequality in South Africa. In the article, I explore the impact of the COVID-19 pandemic on vulnerable people in South Africa in the specific context of poverty and inequality. I do so by first looking at the conceptual contexts and then highlighting the extent of the impact, both from a constitutional and human rights context, and also from a legislative context. I use the poor and vulnerable as a proxy to explore the impact of the pandemic on the specific constitutional rights of vulnerable people. I also look at the measures put in place to contain the pandemic. And as part of my conclusion, I suggest a human rights-based approach to managing the pandemic. It's not possible, of course, to go into great details of the article, but there are a few things that I particularly want to highlight. Firstly, that poverty and inequality are two major defining features of the majority of the South African population. Secondly, that these people are the very same marginalized groups that are usually vulnerable to disasters such as famine and hunger, wars, civil instability, epidemics and pandemics, etc. Thirdly, that the pandemic and the measures developed to control it led to the limitation of several civil, political, and socio-economic rights of everyone, but particularly of the poor and vulnerable. For that reason, and because poor lives matter, a human rights approach to managing the pandemic is proposed. Now, in proposing a human rights-based approach, I highlight a number of human rights principles that underpin the approach. These include the principle of accountability and transparency, the principle of participation, the principle of non-discrimination and equality, that of empowerment of rights holders, and finally, the principle of legality. Obviously, the length and depth of this presentation do not lend themselves to a detailed discussion of these principles. Suffice to say that they are part of a broader set of United Nations guiding principles on extreme poverty and human rights. Now, besides proposing a human rights-based approach, of course, the article concludes with a number of recommendations or actions. The human rights-based approach actions recommended are not only aimed at addressing the plight of the poor and vulnerable in the COVID-19 pandemic, but are also applicable to any pandemics that might occur in the future. Some of these actions recommended relate to the protection of the socio-economic rights of poor and vulnerable people through the provision of basic goods and delivery of particular services, such as healthcare services linked to the pandemic. Others relate to measures that should be put in place to eliminate any corruption that may occur in the provision of healthcare and other resources to vulnerable groups. Yet others relate to social security, support for learners, particularly those from poor and vulnerable communities, etc., etc. It is then finally concluded that despite the South African government having undertaken some of the actions recommended, there remains room for improvement and there remains scope for further research because the pandemic is expected to continue for some time. Now, let me end by thanking the Journal of African Law for having run this special issue of the journal. COVID-19 is such an important and topical issue that it was indeed deserving of a special issue. In fact, because the pandemic is still ongoing and we don't know how long it is going to take, maybe another special issue is actually due. Thank you.
Thank you very much, Professor Mbangi. for that amazing and interesting contextualization of the contrast of people who live within poverty and their susceptibility, especially within this context of COVID-19, but also within the context of any other shocks that are usually thrown towards them. So just as a reminder, Professor Mubangi's paper was on Poor Lives Matter, COVID-19 and the plight of vulnerable groups, with specific reference to poverty and inequality in South Africa. And I think as we move on towards this discussion, his paper becomes very important with reference to the majority of people living on the African continent who in one way or another are excluded from, for instance, social security measures, access to basic services, affected by corruption the most. And so it becomes an important discussion that we can even extend and use as comparison or a basis for comparison with other African countries as well. Our third group of panelists is going to be Kalorian Jacobs, as well as Patrick Milabio Kiamshungura. I hope I'm pronouncing his name very well. We might struggle getting access to Patrick, as I pointed out earlier, because I think he's in Bukavu and he might have issues with some internet. But we'll see if Caroline will be able to present the paper on our own, and hopefully Patrick can join us. The paper that they are presenting is on containing COVID-19 in the Democratic Republic of the Congo. And it specifically looks at government measures and women's compliance. Kalorian?
Yes, thank you. I hope you can hear me. I'm indeed trying to get in touch with Patrick, but I haven't received a response yet. So I will just start, and then if he comes in, he can join and take over. So the paper that the two of us wrote together with our colleagues Rachel Katambere and Henry Kitinto is based on 134 structured interviews with women in Bukavu, a city in the east of the Democratic Republic of Congo, the DRC shortly, or Congo. And our paper is rooted in social legal studies mostly, with some legal analysis of the measures that were taken. And for this, we took inspiration, first of all, from the work by Simon Kashigudu on the cholera epidemic in Zimbabwe, where he analyzes the social, cultural, and political factors that impact on the way in which the cholera epidemic unfolds in his experience, arguing that it's the political life of an epidemic. That's the title of his book, which I think is an interesting read in this regard. And secondly, we took inspiration from the work by Tyler on why people obey the law. And in his book, Tyler distinguishes first an instrumental perspective. So people weigh basically the consequences of violation of the law. What is the risk of being caught? What is the severity of the sanction? And for an instrumental approach to be effective, you need either strong enforcement of the law or make it very easy for people to comply. So you have free masks available, sanitizers, it's easy to keep distance, etc. The other perspective is a normative perspective. So there people obey the law because they agree with it, either because they are fine with the actual content of the law, or because they trust that the government will come up with the right law for them. And this obviously requires high levels of state legitimacy or a good understanding of the way in which disease transmission can be curbed, so people internalize the norm. So in sum, we felt that the COVID sanitary measures can learn us a lot about the mechanisms behind compliance and law enforcement, which is a sort of larger social legal question that all lawmakers basically puzzle with. So the Congolese government very quickly declared a state of emergency, and that is one thing, but enforcement is something else, especially in a context like the east of the DRC, where trust in the government is not particularly high. And an advantage there for the Congolese government was probably that Congolese people are generally fairly positive about healthcare provision in their country, whether or not this healthcare is provided by the state or by non-state actors such as the church. And this feeds into the perception that people have of the state in general. So that's the positive side of this. Now, initially, COVID was most prevalent in the rich, basically the expat neighborhoods in the capital of Kinshasa, so places with strong connections with the rest of the world. And I think we see that in other countries in Africa as well. So therefore, it was associated with the whites and the rich, and people in Bukavu in the east, which is quite far away from Kinshasa, of course, didn't really bother so much about it. But at that point in time already, there was a very quick response by the government also based on experiences with Ebola outbreaks. So that's something which we should also consider, that Congo has a lot of experience with an epidemic like Ebola, which is highly contagious. Some measures were taken at national level, others at provincial levels, and then further refined at municipal levels. We asked our respondents about the knowledge they had about COVID. They had a fairly good knowledge on the symptoms, sometimes confused these with Ebola symptoms, which is not surprising because there was a recent outbreak in one of the neighboring provinces where we did our research. And knowledge was usually obtained via radio, TV, churches, and friends. And the measures that people mentioned were the obligation to wash your hands with soap or with ashes, to wear a face mask outside the house, to avoid group meetings, physical distancing. And respondents generally appreciated the work of health workers in providing information, but they also pointed out that these health workers should be paid proper salaries by the state, so pointing at a shortcoming of the state. And elder respondents were usually aware of the provision to leave the home, because at that time, people above 60 were not supposed to leave the house because they were considered to be particularly vulnerable. And this was seen as a measure that was more or less feasible because people over 60 usually didn't contribute economically anymore to the household. What people did notice was the provision of church services and the closing of schools, which made people very much aware that there were measures taken against the virus, and this also impacted on their everyday routines. And many women regretted the closing of churches for two main reasons. Firstly, because they felt that, especially in these times, God would be able to help them. And also because the church closure meant that the solidarity network that the church provides in regular times got interrupted, was broken basically, and they didn't have easy access to this anymore. So when we asked people about their compliance with the measures, we found that many respondents feel the need to protect themselves and others, and they felt that the measures contributed to better protection. They would usually not distinguish between national and provincial measures. Well, I ensure the application because it's a state law that protects us, so we have to do it. Basically, that was the feeling. And a large group of respondents complied with the measures because they felt better protected, because their pastor had told them to do so. But others also complied mostly out of fear of being sanctioned, fear of being arrested, of being harassed by the police, of having to pay a fine. So that's the perspective that you see there. And generally, people seem to be more fearful of being sanctioned in the central places of the city than in the periphery. So you see different degrees there. And that's certainly related to the fact that the police is more present at the central places of the city, at the market, important traffic hubs, and people run higher risks of being fined. Now, we also asked our respondents, the women, what they thought about the way in which national, provincial, and municipal authorities had responded to the pandemic. Generally, levels of trust are quite low, but we noted that a lot of our respondents actually expressed more mixed feelings about the government rather than fully negative opinions. If you would ask them about government in general, they would often be very negative. So many people felt actually that the government did well in having these very early measures, which I think is also something which we see in many African countries. Measures were much quicker taken than in Europe, for instance. People felt that this had contributed to contain the pandemic and to avoid high numbers of contaminations. But at the same time, they felt abandoned by the government because of the lack of any material support, such as livelihoods assistance, and the closing of the churches that further exacerbated people's suffering because of the lack of access to solidarity support that they could get there. So that reduced opportunities for support. People usually did not criticize the state authorities for not providing any support, but rather reproach the authorities for cutting off the support that they would get through the church. So basically, it's an indirect blaming for a lack of support. Now, in our paper, we conclude that we asked the question, finally, what does this tell us about compliance and legitimacy? I think generally we see that the government imposed a number of strict measures at a very early stage of the pandemic. And if we then relate this to these instrumental and normative ways, we see that It did not matter much to our respondents whether measures were imposed by the president or by the provincial governor, whereas we know from earlier research that we've done in this region that people are usually more positive about low-level authorities than about the distant high-level national authorities. Our findings also show that deterrence plays a major role in motivating Congolese women to comply with state-imposed sanitary measures, especially because they want to avoid police harassment. And this deterrence also leads to what we call in our paper sort of creative compliance. People play with the rules, stretch them as much as possible at their convenience. So they wear masks in public, but only in certain public spaces and not in the periphery. And women know that the sanctioning police officers are not present everywhere, and that they can often also buy their way out of sanctioning, which I think is quite a common practice in many places. So the discretionary power to apply the law in a flexible manner is in this case not only in the hands of state officials, but also in the hands of the population who bend the rules themselves, especially at the periphery of the city where the police is less present. So from a normative perspective, the women we interviewed complied because they feared falling sick and because they expected that the measures could prevent this. They learned about the modes of transmission through awareness-raising campaigns, so that shows the effectiveness of such campaigns to ensure compliance. And that's not only about the measures, but also about the rationale behind these measures. And a smaller number of respondents indicated that they complied simply because either the state or the church told them to do so. And the obeyance of the law here, because it is the law, was then actually often still induced by religious orientations, by church leaders telling people that they had to follow the law. So then indirectly, the church leaders actually contribute quite a bit to the levels of compliance with state measures. And that's basically what we conclude with. And I agree with the previous speaker that it would be really interesting to follow up again and see how this has developed, because of course we all know the pandemic is dragging on forever, and yeah, measures are still taken, but they're also not super feasible for people. So we did our collection of data in September 2020, so that's already quite a bit of time ago. So it would be interesting to follow up. So thank you.
All right. Thank you very much. I'm not sure if I'm pronouncing your name well. It's Calorian or Calorian. But Caroline. Yes, thank you. Okay, Calorian.
No
okay.
problem.
Thank you. Thank you very much for that. It was a very fascinating discussion that actually takes us on the ground. And I think in a way it builds on the discussion that Professor Mubangizi engaged with from a legal point of view. What was the impact of those measures on poor people, or where did they get impacted at all, or whether their poor lives mattered within this particular context. And I think your presentation takes us to the ground to look at how people on the ground, specifically looking at women, when we look at vulnerable groups, and how they interact with the measures that are essentially presented to them, whether those measures matter at all for their lives, and the implications of the pandemic on their long-term livelihoods, for instance, and how they creatively navigate that. So thank you very much for that particular discussion. I think we'll come back to it strongly when it gets to the question section. But I want to start with one question that there are some questions that are coming in right now. There are questions that are there for Professor Mubangizi, and I think I'll build on mine there. And there are questions that also there for, I think the first presenter, I think one comes from me, and Lutz has also asked questions. So I think I'll start with the first question that I see in the chat here. And the question was from Claudian Kabanda from Rwanda. His question is specifically for Professor Mubangizi. I think he says, what should African countries be left with after the pandemic? Or the way I interpret his question is like, what becomes the future perhaps of African countries after the pandemic? And in the context of the future, for me, it's like, what are their health system or their public systems, their governance systems looking like after the pandemic? What lessons do they pick from this particular pandemic? That first goes to Professor Mubangizi, but I think later on I will just extend it to all the panelists. Professor?
Thank you again. Obviously, that is Claudian's question is a broad question as to what can African countries do. Well, let me begin by saying that what COVID-19 has done is to expose the disparities between countries, the so-called developed countries and the so-called developing countries. The disparities in terms of resources, in terms of finances, in terms of adequate health systems and all other systems. Now, as I said in my brief presentation, and as I say in my paper, well, South Africa and many other African countries have done as much as they can do within the limitations or within the limits of the resources that they have. But I guess in the context of my paper, probably the question is, what can African countries do within the context of the protection of human rights of vulnerable people? And that is why I propose in my paper that maybe a human rights-based approach should be adopted. And of course, many people will ask, well, what is this human rights-based approach all about? Obviously, there are different definitions of what a human rights-based approach is, but I just take one that would probably capture it succinctly. One would say that that approach is about empowering people to know and claim their rights and increasing the ability and accountability of individuals and institutions who are responsible for respecting, protecting, and fulfilling these rights. And what this means is that you give people greater opportunities to participate in shaping the decisions that impact on their human rights. It also means increasing the ability of those with responsibility for fulfilling rights to recognize and know how to respect those rights and make sure they can be held to account. So that is what a human rights-based approach is all about. So if you look at what has unfolded over the last 2 years, to what extent have the poor and vulnerable been involved in decision-making regarding the rights that, regarding the way that the COVID-19 has impacted their rights, not only in terms of health, basic health facilities, but for example, the question of vaccination. I could go on and on and on, but I think what African countries can do is, take the issue of human rights seriously in the way they deal with pandemics. Otherwise, as far as other things are concerned that involve resources and other things that are not available, they have done as much as they can. I hope I have attempted to answer your question. Thank you.
Okay, thanks, Professor Mubangizi. And I think on that particular last point, it almost went into what I'd also wanted to ask you. So when we talk about African countries responding from a human rights point of view, including engaging the socioeconomic rights of the vulnerable, what happens when it's a question of resources? For instance, we see vaccine distribution, which is in one way or another unequal around the world. And I think you've answered that when you've pointed out that when it comes to that, they can do everything they can within their capacity, but then they can't go past that. Perhaps for me, one last angle to that before we move to the next question is the issue of not just limited vaccine to access, but within specific socioeconomic contexts. What about the issue of knowledge, sharing knowledge, education, especially public health awareness, when it comes to the issue of, for instance, fake news around vaccines? Does that fit into the human rights knowledge awareness framework as well, or is it something completely different?
No, it is not. It actually fits in the human rights framework, because what you're actually talking about is the right of access to information. How much information have people been provided with? But even if it's not just about provision, how are they able to access that information that impacts on their lives in the context of COVID-19. You know, much of the resistance, by the way, against vaccination is actually based on insufficient information. If you hear the arguments that the non-vaxxers make, it's you know, most of them it's because they actually lack the sufficient information that would guide them to understand the uses and benefits scientifically of vaccines. So the question you are posing about, you know, people knowing, it's basically about a constitutional right to access to information. I don't know whether I've answered your question.
Thank you very much for that. You've answered my question very well. And I'm going to take that discussion on to the second question now that was posed by Lutz Oyet. Lutz asked a question. It's targeted at panelists, but also at everybody else. It can get our discussion going. His question is, what do you consider to be the main human rights lessons or implications from COVID-19 at various levels within the African context, national, sub-regional, and regional? How should these lessons inform future rights agendas across Africa, beyond obvious the focus that we are having on the right to health? So first questions, what are the main human rights lessons and implications and at different levels? And two, how should these particular implications and lessons inform future rights agendas across Africa? I will start with Mansha Mohi, and then move to Caroline, and then lastly to our presenter, Professor Mubangis.
Thank you. I think in terms of democracy during the pandemic, it became clear that democratic governance is really central to the successful containment of infectious disease outbreaks. This is because not only are executive powers heightened in states of emergency or disaster, but because populations vitally depend on public goods. And I think in terms of regional responses, there have been regional bodies have seized the opportunity to clarify standards, human rights standards, and legal standards in the conduct of elections in that context. But I would say that they have done so with significant delay. Nonetheless, the contributions they've made now are quite rich. But what is really lacking going forward and what needs to be focused on is probably legal certainty at the domestic level. So in terms of countries beefing up the legislation to provide for those difficulties that arise during a crisis. So I think I've highlighted some of them, but specifically around derogation of rights in emergencies, in the specific context of elections, the legal regime applicable in situations where there may be a power vacuum, and so on.
Thank you, Mansha. That really presents a part of that answer to Lutz's question very well. The vacuums that you find within our legal systems, legal uncertainty, democratic governance, as you point out, with some of our leaders taking advantage of the situation, as you said in the beginning, to present political tactics, for instance, for suppression and the likes. Thanks for that. Caroline?
Yes, thank you. Yeah, I will, I think, combine some of the questions in my response because I'm reading some of it. I think in terms of human rights, I would say, and that is probably my legal anthropology voice speaking as well, I would emphasize the importance of context and not having a sort of one-size-fits-all approach. And I think a lot of African countries in the beginning of the pandemic were basically copying a lot of the measures that were taken in Europe, in Asia, for instance. But these measures do not necessarily work in the same way in a different context. And I think especially a country like Congo, but also Liberia, Sierra Leone, where they had these huge Ebola outbreaks, they have lots of experience with contact tracing, with isolation, that they could also build on. So they actually didn't start as much from scratch as we in Europe did with sort of containing a very contagious virus. And I think, that requires a sort of more maybe self-consciousness among these countries of saying, hey, we actually know how to deal with a lot of these things because we have been going through it already. And also that you should consider this context to see what is feasible. And that's why I mentioned the example in my presentation of the Congolese government prohibiting people over 60 to leave their houses rather than a whole population, which some other African countries did. And I think it is a smart way of saying, well, we know that lots of people can't afford to stay within their house for a day because they will have to provide, to find food, to make, well, basically to earn the money for the day to get some food on the table. So instead of saying that everybody has to stay inside, we say that, well, we know from others that older people are more vulnerable, so, but they are not usually the productive part of the economy. So if we ask them to stay inside, maybe reduce the risk a little bit, and that doesn't impact as strongly on the economy for vulnerable groups of people. And I think that is a good way to deal with it, to consider as well what is possible within your context in your country, and that African countries do have a lot to say. And I guess in Europe we are maybe probably too sort of arrogant to look into the way in which Congo has dealt with its Ebola epidemics in the past and to learn lessons from that. But yeah, we could also learn lessons there. And then I guess that means tailoring these approaches and not saying we need one approach. And we've seen that contact tracing and isolation and lockdowns work. So it probably also works in our context, because that's not necessarily the case. And somebody was mentioning the rural-urban divide. I think if you look at containing the pandemic, people in rural areas, they are more isolated. So the spread of the virus was much slower in these areas usually. And it is easier simply to keep distance in the rural area where you have a bit more space, and maybe also to sort of trace contacts that people have than in a city where, urban neighborhoods in the periphery, they are often very densely populated, very packed. So keeping distance, well, if you're with 15 people in the house, you will not be able to keep distance at all. So that is a measure that doesn't work. So that is again where you should distinguish rural and urban context, level of poverty. Are people able to remain within the house or not? So that would be the approach that I would favor, I guess, in terms of context consideration.
Okay.
Sum up.
Thanks, Caroline. And I think I saw the question on the rural urban, and I found it fascinating that there are areas, for instance, in Kenya that did not encounter COVID earlier on, rural areas, until a bit much later. And I think one of the government approaches there at some point was to lock out city centers like Nairobi separately, so that people would not actually start moving between rural and urban areas and essentially facilitate the spread. But also, as you're pointing out, yes, there's that likelihood of contact tracing because of the communal networks as well within rural areas that looks different. So people in rural areas also happen to know who in what house is actually unwell, as opposed to people within towns and stuff like that. But obviously, when COVID would arrive in rural areas, the implications, I feel, would look differently, considering the facilities that happen to be limited within rural areas, where people would have to travel for miles just to find a place where they can get the necessary social services. Last is Professor Mubangizi on Lut's question on human rights implications and lessons from COVID-19.
Thank you again. The way that question is framed or phrased, one would probably need an hour or so to answer it sufficiently. But I'll attempt to give a very brief answer. So when you talk about human rights lessons to be learned, well, I guess the first basic lesson is that COVID-19 is not the first disease to ravage humanity, and it will certainly not be the last. And we've all heard about the Spanish flu, the Asian flu, the AIDS epidemic, the H1N1 swine flu, the West African Ebola epidemic, and so on. You can name them. So I'm not sure why we were surprised when COVID-19 came around, because it was bound to happen and is bound to happen again. And that should inform the lessons that we should learn from COVID-19. So one of the lessons for me, and in the context of the paper I wrote, is that poor lives matter. It is so easy to ignore the poor. And well, simply because the poor are usually voiceless. And that's the basis of my paper. So because poor lives matter, and because they are essentially or largely voiceless, poor people need extra protection, particularly in the context of human rights. That's on one side. The other side of that coin is that the protection of human rights is actually important in everything we do. And that's why I talk about a human rights approach, a human rights-based approach. The protection of human rights is important because if you don't protect human rights, then you are not actually achieving what you should achieve. And this is based on the basic definition of the term human rights. As you know, the basic definition is that human rights are those rights that we have simply by virtue of being human beings. We don't need any other qualifications or any other qualification to enjoy human rights. So it is important that we build human rights in everything we do. And so an important lesson that we learn from COVID-19, both at national, regional, international level, is that we should use a human rights based approach whenever we are dealing or trying to deal with the pandemic and any other pandemics that may come in the future. I could go on and on and on, but I leave it there and say those are 2-3 basic lessons that we learn from COVID-19, human rights lessons that we learn from COVID-19. Thank you.
Thanks, Professor Mubangizi. I think here Lebohang Motopi also on the chat throws in a comment here and says that in my view, I believe food security and access to clean and running water can be a greater start to driving and informing future agendas for African countries. I think that's also in response to Lut's question on what should, how should these lessons perhaps inform future agendas for African countries. John McLean here asks a question. Welcome, John. Nice seeing you. He asks a question and says, good afternoon, colleagues, and thank you for this timely publication. Obviously, the pandemic affected all African countries. Did your study compare African countries in terms of how they responded and the social and legal strategies deployed, e.g. within countries and between countries? Perhaps in responding to that as editors, I don't think we had, and Lucia may help me, but I don't think we had a paper that actually compared approaches besides Mansha Mohi's paper that looked at Africa widely, and I'll give her an opportunity to respond. I'm not sure there was another paper that just did such a comparison. So a comparison on African countries in terms of how they responded and the social and legal strategies deployed within countries and between countries. Perhaps Mansha can come in here for the specific electoral governance approach that she had in her paper and just respond to that.
Thank you. Also, apologies, I'll have to stick to audio because my internet connection is quite shaky in Abidjan. Okay. I think the comparative analysis for electoral governance, especially at the start of the pandemic, kind of shows that governments really resorted to different measures. And so the responses were quite diverse depending on national context. And as I think I pointed out also, we can see that as the pandemic hit the continent, some governments held elections as planned, others postponed elections and drew up new electoral timelines. And this is because of, this can be explained by a range of reasons, notably logistical reasons, and basically also how badly countries were being hit by the pandemic. So in terms of their responses, I think we can say that most responses took account of the local context, but one important thing that needs to be pointed out, and I think this was also highlighted in other studies, is that governments did not adequately consult the health authorities as well as civil society in their decisions. And this explains also the impact of the human rights implications of those decisions in 2020, and also as the pandemic progressed through the continent.
Thanks, Marsha. I think also your response and John McLean's question was looking at, first of all, legal strategies, but also social strategies, or strategies that might have social implications, perhaps. And it's interesting what comes out of your response, that governments actually perhaps do not engage with public health authorities as much as they should have. And I'll leave the social aspect as well open, and we'll go on to discuss it, because this question is wider than just legal strategies, also social. What were the social and probably legal strategies that were deployed within and between countries? So I think for the social strategies, it might be interesting for Caroline to come in here. Obviously, she wasn't comparing countries, but specifically to look at the DRC's approach.
Yeah, I think in DRC, the particularity there is that the health system in general is operated to a large extent by non-state actors. So the church has always been very active in providing a lot of healthcare, and this means that a lot of the actual work on the ground by health workers is also done by non-state actors. But we know from other research that this, nevertheless, like if healthcare improves in the country, that this impacts slightly also on the perception that people have of the state. So that's quite convenient for the government, because if others improve their work, because the government is still providing the sort of regulatory framework, it impacts positively on them. And in that sense, these health workers, whether they were state or non-state, had an active role. You could call them civil society, I guess. Church is also always a little bit sort of where they position, are they civil society or not? But they certainly were important, and that, I think, contributes to a very large extent to people knowing about the virus and what it would do, and also to know about the measures that were taken by the government. So that was really important. Maybe a short note in response to the question about comparison. I had my students doing this assignment in class where all the students had to pick one African country and then look into the measures that were taken. I think it was in April, March 2020 that I did this assignment with my students. And in general, I think African countries were much quicker in taking quite stringent measures against COVID than European countries did, for instance. I remember myself as well traveling to Congo in February 2020, when at the Rwandan airport, there were already a lot of measures. There was temperature check, there was a sort of questioning upon arrival. Also at the Rwandan-Congolese borders, there were already checks, temperatures were measured, and nothing of this was in place in Europe upon arrival and traveling. And that was mostly because the general fear that, well, we see that in Europe and in Asia, hospitals are overburdened. And we all know that African countries usually have less capacity. So we should avoid this situation at all costs. But I think we've also seen that somehow the epidemic has been less out of control in many African countries than it has been in many other countries. And whether this has to do with the early measures that were taken or with other factors, I guess that's still a question that is quite open, but it's an interesting question to understand as well, the spread of the virus.
Thanks, Caroline. Lutz, you wanted to come in here?
Yeah, thank you, Olivia. Just to say that unfortunately we won't be able to take up the offer of having another special issue on COVID-19 and law in Africa, but I think that the question alludes to, I mean, the huge research potential, I think, to focus on both processes and substance. And I think Manjama made it clear, I mean, that you have to then focus specifically on certain issues. And I think there are a number of them to focus on in this research agenda. But I think you can, if you really want to have a comparative analysis of strategies that all the various actors have taken, I think it would be a huge volume, because what COVID-19 has done, I mean, not only in Africa, but worldwide, I think is sort of to invite us to sort of scrutinize the anatomy of governance, if you like. And obviously that has huge rights implications. And I think a couple of questions raised in the chat already maybe deserve our attention to focus on emergency laws, even though I would say it's a double-edged sword, because a lot of the emerging discussion has been focusing on emergency laws, and I think rightly so. But what we've heard here so far, and I really like also the John Mubangingze's focus on Poor Lives Matter, is on the broader structural factors and if you like, structural violence experienced by people. So it's very, I think it's very challenging to get all of the balance right and to cover the whole spectrum of issues that we need to focus on. And obviously, I think emergency legislation is very important as a power grab in countries where governance is often already weak, but I think it needs to be situated also within this much broader context.
Okay, thank you very much, Lutz. And that also brings me into the question, the larger question that Rashida Manju had presented. So there was a larger question on rule of law by Rashida Manju that for me, I feel would build into the questions by Ebenezer and the discussion and question by Jaap de Visser on the role of courts. So I'll start with Rashida's and then we can build into the role of courts, at least from that particular point of view. So that also builds on the larger question of emergency rules and policies that Lutz was talking about. But it also gives us specific responses and what the role of specific legal institutions can be in the future, if that helps at all. So Rashida Manju, welcome Rashida to this particular session. Thanks for being with us. Our question is on the concerns about regulations, COVID regulations. So this is specifically building on from what Lutz was talking about, these emergency measures. And she says there was concern that these measures were draconian in the view of some or many. What are the implications for rule of law, for instance, moving forward now, and the separation of powers and governance? Because this emergency context provided an opportunity for a lot of what would look like derogations. It built on the fragility sometimes of some institutions for certain African leaders to governize themselves. So moving forward, what are the implications for rule of law, separation of powers and governance? We saw politicians behaving like law unto themselves during this particular time in how they formulated and interpreted and enforced policies. So I will give that question to Mansha first, and then we can move to other panelists.
I guess a short answer to this could be that given the propensity for executive power to be concentrated in such times, is that we need to also reconsider the role of regional bodies, and you know, consider a strengthened role of our regional mechanisms. Even when studying this particular issue in 2020, it became clear before clarity was provided by some institutions, some of the regional institutions, that there's still uncertainty around the international legal standards. And here I'm speaking specifically around the conduct of elections. So I think if we were to think of an approach going forward that could help in this context, because there's always the tension between states affirming their sovereignty in those matters, and we know the consequences of that, especially in times where populations are even more vulnerable and depend on good governance for survival, basically. So maybe the discussion should be more around how we can build our regional mechanisms and instruments stronger to provide for safeguards, better safeguards in the scheduling of elections, in their conduct, but also in terms of limiting abuses in general.
Okay, thank you. So that's Mansha's response. I'll also raise this question for Professor Mubangizi, and I think I'll add the question by Ebenezer there for Professor Mubangizi to respond to as well. First of all, what would be the implications of such a vast powers that our leaders amassed for themselves for the future of rule of law and separation of powers? But also then what would be the role of African courts in addressing human rights issues that have been raised by COVID? So on one hand, you have these larger the amassing of a lot of powers, the governing, and the almost the display of disregard for separation of powers. And on the other hand, you have African courts that are supposed to be able or be placed to do something about this. How do we reconcile the two? What would be the role of these African courts in addressing human rights issues raised by COVID, including perhaps violations that would happen as a result of these draconian laws that were misused sometimes by some leaders?
Thank you again. That's another broad question. I will take it together with the question I saw in the chat line posed by Etienne Mutabazi, I think, because they are similar. He was asking about what do we make of the measures enacted to contain the pandemic? Most of the African countries, what they did, and the toll on human rights. He gave an example of Rwanda where some people were shot as a measure to enforce the containment measures. I thought that question broadly, ties in with the one you've just posed. So first of all, the question is whether the measures enacted were necessary. Well, yes and no. You have to, there needed to be a balance between the enjoyment of individual rights and, of course, the protection of the collective rights of the greater society or the greater community in terms of protecting them from catching COVID-19 and dying therefrom. However, I guess some of the measures really were unnecessary and they went overboard. I'll give you two examples. When we had in South Africa, that very hard lockdown, I remember they were forbidding us from buying hot food, for example. or from buying open shoes from the shops. I don't know what food and open shoes would have to do with the protection from COVID-19. And of course, there was this big story about smoking, banning the sale of tobacco products and smoking, for a long period of time. And of course, some of these ended up in court, which brings me to the question, about the role of courts. Of course, courts will always have a very important role to play. They will have an important role to play because of what you have mentioned, the separation of powers here and the rule of law. Here where, leaders, political leaders, making laws, if you wish, and people do not like it. But one of the reasons that people do not like it is that people actually don't like being told what to do. People don't like being told what to do by certain other people. And that was, I mean, a major problem in South Africa. And some of these ended up in court. And of course, the courts have the right to pronounce on these. And it's because it is the responsibility of courts to pronounce on these issues. So the issue of African countries and the way they handle this, obviously, many African countries, of course, I know the less said about Rwanda and the human rights record in Rwanda, the better. But I could say that many countries have unfortunately used COVID-19 to crack the whip on their people and clamp any dissent or opposition to the leadership. If you lock down a country for 3 or 4 or 5 months, you are sure not to expect any protests, any opposition to your leadership, because people are locked up. So many African countries and many African leaders abused this particular process to lock up the countries and crack on and clamp on any dissent in their countries. And again, obviously here, the roles play an important role. Obviously, this principle of separation of powers between the various organs of state was put to a test by this COVID-19. And I don't know about many other African countries, but I think the South Africa, had its own problems, but I think it fared better or a little better than other African countries that I know of or that I have been to since the COVID-19 pandemic started. Thank you.
Thank you, Professor Mubangizi. And I want to extend that to the role of regional courts. So you have domestic courts. For instance, the discussion we are having where some of the issues of these issues and including violations were raised in domestic courts. But then the second level becomes what then becomes the role of regional courts within such a context.
Sorry, I can't. Well, they still play their role. I don't think that their mandate should change. They should continue to play their role. But as you know, the principle is that they should basically deal with matters that where the internal processes in the countries have been exhausted. So if there are situations like that, I don't see why the regional courts or the cannot play an important role. Unfortunately, I'm not aware of any case that has come before the African Court, for example, of human rights. And but I don't see why they shouldn't continue playing their role or even play it more, because there are more issues that are going to be coming from the different countries that subscribe to the court.
Okay, thank you very much, Professor Mubangizi. I want to go to a discussion that was laid out by one of our participants here. His name is Bulelani Mkorweni. I hope I pronounced it well. And he says that I stay in 3 environments: rural environment, which is Eastern Cape, and I think this links to one of the questions on the rural-urban divide and the issue of the right-based approaches in responding to COVID-19. So he says that I stay in 3 environments. Burelani could also be a she. in rural Eastern Cape, in a township in Johannesburg as well, and in the suburb in Pretoria. I move around my 3 homes almost seamlessly. It was quite interesting to observe during the peak of the pandemic how South Africa is a country of polar extremes, and yet law and governance was or is blind to all of this. So people were not treated as per their context, but through a blanket approach. In the township, I observed people lived their lives as if there was never a pandemic. There are many reasons to this. For instance, crowded spaces that made it impossible to adhere to restrictions. In the rural area, on the other hand, people were mainly scared of the unknown, as information came in drips and drabs. So the question of access to information, and as is always the case in rural areas, it also came in the dark. Otherwise, after the fear subsided, people in the rural areas went about their normal lives. And then in the suburbs, people basically behaved like they were in Europe. So lockdowns and everything else, and working from home, obviously, because they could afford to. Can't law and governance be developed as per context instead of blanket laws and blanket governance? So this is for all the panelists to have a discussion over. Do you think it's possible within the context of African countries that happens to have people heritages? They have rural areas, they have urban areas, they have slums within urban areas. Is it possible to develop governance approaches to, for instance, pandemics and the likes that are not blankets, that are specific for particular context? And perhaps I'll start with Caroline.
Yeah, thank you. I think it's nice observations that you describe indeed these 3 different settings. And it's certainly true, I would say, that the pandemic or the epidemic did impact differently, and also people respond differently. In Congo, there were different responses at national level. There were general measures, and those were tailored at provincial levels and also at municipal levels. So at some point, this also basically means shutting off cities from the environment. So people were not allowed to travel between different places, because that is where I think the caveat is. It does make sense to have different approaches, also depending on the intensity of the pandemic. And I think in most African countries, contamination started because people were traveling internationally. So you may need different approaches, but I think you have to realize that all these places are connected. You say yourself that you stay in these 3 different environments. So if contamination levels are low in rural areas, if people still travel back and forth between the rural and the urban areas, of course, there is a risk of further spread of the virus. So that is what you would have to take into account as well. And I think it's often difficult to completely lock certain cities that have lots of cases, for instance, to lock these cities off from the rest of the environment around it, because cities are also fed by food that is coming in from the rural areas, for instance. So if these cities are sort of in lockdown and not connected to the rural areas anymore, then the food will also not come in. So that is where you will have to consider additional challenges there, I think, in terms of the economy and feeding the cities, for instance, if you would tailor policy a bit more. But yeah, in general, I would say it makes sense to consider having different measures at different levels and also at different moments in time, I guess.
Thanks, Caroline. Actually, there are those who would even argue that perhaps what Bulelan is describing is maybe the idea that some of these responses were copy-pasted from elsewhere, so they didn't work for the whole country. But you had already digested that and you had already broken that down. And I think even in the charts, there's somebody who has responded to that and said it's not just a matter. It's not just about saying that these were copy-pasted mechanisms. Obviously, they were specific to particular contexts, but it's just that perhaps also the governments themselves were not in a position to be able to have very specified responses within the countries themselves based on the resources they had. And the likes. I was trying to find that comment, which I found very interesting from one of the responders. I think it was Lebohang Motop who said that I don't think it's necessary to categorize the responses as copied and pasted because of the way maybe they failed to address different needs in different parts of the countries. In fact, the response mechanisms were standard and broad. They were made compulsory by the World Health Organization. And so our argument is that perhaps they were not, it's not an issue of them being copy-pasted. Perhaps it's an issue of something else. But maybe not the mechanisms themselves. Maybe it's within how the states interpreted them, or the resources the states had, or lack of resources thereof. I'm just going to look at a few last questions. Soraya Bukes says, going forward in South Africa, we should not allow the executive implementing regulations that could infringe fundamental rights without parliamentary oversight. So that's one of the responses there. But I think somebody had presented an interesting discussion that I want us to go into as we close down here. It was, I can't find him. Let's see if I can find this. Here it is. There's so many charts here. I can't get to the person, but it was a very good discussion on national versus subnational capacities to respond to particular issues. Yes, it's Clifford Bob who said that great set of papers on human rights impact. But it seems that the critical threshold issue affecting all human rights values is who gets to declare and redeclare emergencies, and on what basis? This question goes well beyond African countries, of course. To what extent has this question been raised in various African countries, as it has increasingly been raised in other countries? Do we have enough controls on such declarations, even in democracies, i.e. involving legislatures, not just executives, involving subnational units, for instance, and not just national governments? I'll give this question to Mansha.
Thank you, Dr. Rwambukuna, and thank you also, Clifford, for the question. I think my response to his question would be that the controls maybe that are crucial in such circumstances can be well, we can define them within the proportionality exercise, which is central to restriction of rights. And I think in the case of elections, the advisory opinion of the African Court, also highlighted this, and specifically on postponements of elections, but also on restrictions of rights in times of emergencies. And I think there was also another question which I would also try to speak to around voter registration and low voter registration and the potential impact of low registration on the integrity of elections. So speaking to that also, low registration definitely carries a lot of risks because basically it risks disenfranchising, a large portion of the electorate. And I think that issue was also relevant to the Ivorian case when they were carrying out voter registration early in 2020, just as the pandemic was, hitting Cote d'Ivoire. And also in Uganda, there were several questions raised around voter registration, the lead up to elections. And I think proportionality in this case, the proportionality exercise is extremely important. And from scholarship and discussions around that time, we can note a number of considerations which would factor into the proportionality test. And that is the timing of the pandemic within the overall electoral timeframe, other campaigning options and costs already incurred, financial constraints, the safety of election management staff, voting modalities and alternative voting arrangements, online observation, mission facilities, etc. And I think how we can ensure that voter low registration does not become a real challenge to the integrity of elections is really, again, in ensuring close consultations with health authorities. Because what we saw, especially in governance around that time, and probably this is a persisting issue, is that there's really a lack of coordination between the authorities, I mean, the health authorities, public health authorities, and the political actors. And so, again, just to make it short, proportionality informed by also the larger process of consultations with national stakeholders, especially public health authorities.
Thanks, Marsha. I think that really goes well into, and I think you were referring to Professor Jaff de Visa's observation and question. Yes, it goes very well into his question on how the decision makers, for instance, courts, deal with scientific data on public health that is required to measure whether going ahead with the elections, for instance, would be convenient in a particular context or not, and obviously the implications of that on the availability of voters. So thank you for that, because that's also has been a question that I've been dealing with. On one hand, I'm wondering about the people who gets to declare, who has the power to make these declarations. Is it one arm of government? Is it all the three arms of government? Are there checks and balances between the arms of government? And that's the question raised by I think Mr. Clifford. But the other end of that is the decision makers. Who gets to decide that we have emergencies, and the other party gets to declare? Who gets to decide that these public health measures can overrun the idea of having an election? Who gets to decide that the amount of voter turnout will not be essentially violating the principles of free and fair elections? And as you're saying, it's always on the basis of a principle of proportionality, for instance. So I'm also hoping that the advisory opinion that was presented, for instance, by the African Court on Human and People's Rights, can in one way or another clarify these requirements for elections during periods of pandemic, for instance. At this particular point in time, I want to bring in Professor Ebenezer Durojaye. Professor Durojaye, as we had pointed out at the beginning, is the head of the Socioeconomic Rights Project at the Dula Omal Institute of the University of Western Cape in South Africa. And he was our guest editor for this special issue, considering his vast expertise in health and human rights. And he was an amazing and very collegial colleague who was with us from the conception of this particular project to the editing and eventually the publication. And obviously, has played a key role in hosting us for this particular launch. So his areas of research are human rights, socioeconomic rights, sexual and reproductive health rights, gender, and constitutionalism. Professor Durojaye is going to come in for our closing session to give us a few closing remarks before I send you all off into an amazing and productive week. Professor Durojaye.
Thank you very much, Olivia, and good afternoon, everyone. I think my task is very easy, just to close the event. First of all, I would like just to extend my appreciation to the editors of the Journal of African Law, Louis, Olivia, and Shokbe, for extending the invitation to me as guest editor of this special issue. As all I've said before, when the call was made, we received a very impressive response. Very overwhelming. In fact, so unfortunately, like we said, not all papers could be published, though they are very, very good papers, which we had to struggle with in terms of how to select. So I think it's also important to thank all those people that responded to the call and made of course, the selection very enriching in terms of what to select. I will also thank those people who contributed finally, but who could not make it to this launch for their contribution. And of course, our speakers today, for contributing and for finding time to join us in this important occasion to launch the special issue on COVID-19 and the law in Africa. Thank you all. Also to thank colleagues who have been working behind the scene, Ms. K. Sapto, thank you very much for providing the technical support to make everything go well. And of course, I must also thank Olivia since last week. She has been in touch with us in terms of how the arrangement for this launch. I think one of the important things which we also learned that discussion about COVID-19, human rights and law issues in Africa, we continue. We are, like one of the speakers said, this is not the first pandemic, and of course, it certainly won't be the last. So it's very important for us in Africa to start thinking about how to prepare for the next pandemic, and how do we handle it? What lessons can we say we have learned from COVID-19 in terms of the human rights issues, and how do we prepare for the future pandemics so that we can handle it better than what we have done this time around. So it's a continual debate. We have also raised the issue of draconian laws or legislation to address COVID-19, the rights implication of that. Incidentally, one of my colleagues, Professor Derek Powell, and I just concluded an edited book on constitutional resilience of COVID-19 in Africa, which will be published later by Macmillan later this year, addressing some of these issues, looking at what court can play to address some of those draconian laws, and even the issue of parliament, work through also can the parliament place in terms of checking the executive so that they don't overstep their boundaries in making such kind of laws and regulations. So it's a continuing debate which we will have to some issues which are also emerging has to do with a mandatory vaccination for COVID-19, which we have not even mentioned in our discussion today. But some of these that will continue in our discussion about COVID-19. So I want to thank everyone, especially our participants. Without you, this launch cannot be possible. So thank you for giving us your time, for staying us to this time. And we're very grateful. And I think, thank you, everyone. I'll just hand over back to Olivia. Yeah.
Thanks, Ebenezer. Thanks for that closing speech. Rashida Manju is asking about the title of the book on COVID-19, I think, and constitutionalism. So you should put that for her and other participants in the chat box there. But I want to take this opportunity to thank all of you, to thank our manager at the Journal of African Law, Rowan, and who has been at the forefront, working in the back, obviously, Cambridge University Press, that was responsible for not just publishing the spatial issue, but also ensuring that it was open access. So we are very grateful for that, to ensure that everybody else on the continent who contributes or would want to read actually has access to this. So we are thankful to Cambridge as well for that. And we are thankful to the Center of African Studies at the SOS University of London, the Center for Human Rights at SOS University of London, the Free State Center for Human Rights that has helped us advertise this, as well as the Dula Omar Institutes and other colleagues that have happily subscribed to this journal or participated in redistributing this particular event. We wish you all a good week and hope to see you again in the future. Thank you and bye-bye, everyone. Bye.
Thank you.